Welcome back, everybody. One of the things we've been doing is actually showing some retro business tips. We've been doing these tips for, probably since 2009. So a lot of it's still applicable. So we just want to show you some of those. But I want to welcome Farrah Kohorst. Thank you so much for coming on the show.
No, thanks for having me.
Farrah, you're with Kahane Law.
Yes.
And your area of practice is what?
Family law, divorce, separations.
Okay, is that typically what compiles that is divorce and separation?
Yeah, divorce and separation. So we do common law couples and regular divorcing couples.
And we were chatting and you were saying that you're very busy.
Always busy. It's a good industry to be in. Turns out we're recession-proof. Yeah.
Turns out you are perhaps the recession is even like anti-fragile, where the recession even helps that sometimes.
Yeah, slightly different questions.
Gosh.
Recession, but yes, very busy.
So what we're going to do here is we're going to talk about working through family law. We're going to talk specifically about representing sellers, and then we're going to move on to representing buyers.
Yes.
We have a lot of questions, so let's pound through them right away.
Perfect.
First of all, let's start with some general rules surrounding family law or working with separating clients.
Okay, and I think when you're dealing with separating clients, one of the first things you need to realize as realtors in terms of how we view the file is we don't care who owns the house or who's on title or who's on the mortgage. If there has been a relationship and if both people acquired the property during the marriage or the relationship, or if they both lived in it, then we view it as both parties will need to consent on the sale price and consent on the sale process. So as a realtor, you may view it as only needing one signature in order to do your listing agreement, but you should be viewing the process as trying to involve both parties as much as possible, because at the end of the day, both lawyers are going to want to know what the sale price is and approve the sale price.
Interesting, because we get so caught up on title. We're
Yes.
just like, oh yeah,
We don't care about
that's
title.
who's on title, and
Yeah.
that's the first time I've ever heard that.
Well, and oftentimes, and not all family law lawyers are really great at catching this, but if a party is on title and the other party isn't, then oftentimes we'll have a CLP that's registered there, which will really trigger you.
A
CLP, Certificate of Lease Pendants.
Okay.
Which means that there's been an application that's been started in Court of Queen's Bench, and then we register a lien against the property, essentially putting potential purchasers on notice that there's another interested party in that, and that would be the other spouse.
Perfect, perfect. You said there's a number one rule when working with separating couples. What is that?
And that's transparency, and I think that's one of the best things that realtors can do when dealing with separating couples, and that goes back to if you think if the husband, for example, is on title, don't think that you don't need to be involving the wife, because she should be involved in every step of the process. And that's going to help you remain on the file and let you close the deal. The courts and lawyers are very supportive of the fact that when we're dealing with this situation, a matrimonial house is oftentimes the greatest asset of the party, and we want the wife to be just as comfortable with the realtor as the husband is.
Now, this is off script already. It took me about 2 seconds.
No, go ahead.
So is the laws governing this, is it Matrimonial Property Act? Is that correct?
Matrimonial Property Act, and then we're talking about common law, which
Okay.
is just a series of case law which governs sort of the common law property.
The Interdependent Adults Relationship Act?
Yes, stuff like that, constructive trust. That's beyond 15 minutes today. But
Okay, yeah, fair enough, fair enough. Okay, yeah, let's stick to
Yes.
the topic. All right. So what happens if a realtor is not transparent?
If you're not transparent, if you have not signed your listing agreement yet, then odds are you're not going to get that deal. Even though you might have done all the work, you might have done all the CMAs and all the prep work with one party. If both parties aren't on side with using you, then you're going to get cut, and then a new realtor is going to get put in. If there has been a listing agreement already, a party can bring an application, have the realtor taken off the file, and having a new realtor put on the file.
Interesting.
So you really, I think it's a way of protecting your file and protecting your deal. And what I do is I've even written this into past court orders. I did one in January, which says that all communications that the realtor has to happen with both husband and wife, so that it's just not a one-sided negotiation.
So how does a realtor do that? How do they accomplish the transparency?
Well, what we did on that file is the realtor, all conference calls, emails go to both parties, emails go to both lawyers. If you can't just contact one party and not the other, and even just meetings, like they're meeting at a coffee shop every time that they have to discuss a sale. And I think they use Call to View as a way for, that's a program that you guys have.
Yeah, well, there's
Yeah.
one, we have some showing services.
Yes,
and things like that.
exactly.
Yeah.
So they do stuff like that to make sure that everyone is getting the information at the same time. And keep in mind, the higher conflict the file is, the more touchy the parties are going to be about the transparency issue.
So the more they're fighting.
The more they're fighting, the more they're at odds.
Yeah.
If you have a really amicable separation, then oftentimes a party will take a back seat and say, you know what, he's always done a good job with our finances. He's going to make sure he's going to handle this. But if people are really at each other's throats, you're really going to want to put in some work on the transparency issue, or else you're just going to find yourself shut out at the end of the day.
Are you off script again?
Yes,
so fiduciary duties. So we have, who is our client, and is it both parties? Is that the way that works? Even though we have one on there, like we're also doing these consumer relationship guides. We're disclosing our, and you guys do that too, where you guys have a client.
Yeah.
How do you balance out your fiduciary duty with full transparency?
Well, and I think the best thing to do is you have to, from our perspective, I think realtors need to be approaching this as, if somebody's lived in the house or there has been a relationship, that person has an interest in that property.
Even through dowry.
And it's a serious interest. Well,
yeah.
dowry is just for marriage, but common law couples too. But they have a serious interest in it, and it's up to the family law lawyers to determine whether that interest is 1% or 50%. But as a realtor, you need to be respecting the fact that they have an interest in the property.
Nice.
So just communicate with everyone as much as you can. Obviously, protect whatever your fiduciary obligations are. I'm not quite sure about that. But if you're not in tune with both parties throughout the process, then I just don't want to see you kicked off the deal, right?
And it almost becomes, it's in your client's best interest
Yes.
to keep the other party and to make it smooth.
Absolutely.
And so and then that way you're still acting in the client's best interest.
Yeah, you're acting their client, because it's just going to slow down the process, because then they're going to have to bring another realtor on. So
fair enough. What typically needs to be done prior to listing the house for sale?
From the court's perspective, the tests that they want is they want financial disclosure exchange between the parties. That usually takes 60 to 90 days following initial separation. And they want proof that the party cannot keep the house. So those two aspects need to be proven out.
That they can't refinance, buy the other person out.
Exactly. And then that'll factor in some spousal support concerns, things that as a realtor you wouldn't be aware of. But until we have those two factors in line, then we're not in a position to list the house yet.
Is there some rules around the timing of the sale?
The timing, so with regard to the timing, this is an as-is system. So as soon as the courts realize that we have financials and we have proof that as much as mom might be attached to the house and as much as mom wants the house for the kids, if mom cannot afford to buy dad out, then the house has to go. As soon as we know that, then it's an as-is system. The courts will not order any upkeep, maintenance, any renovations to be done, especially if there were low finances on a file. It has to go. We're not going to wait until the market turns around. We're just going to sell the house at that point in time.
So now the realtor finds out that a court order is being drafted. What should they do?
I think the best thing to do is always be in touch with the lawyers. Don't feel like you can't contact us. Obviously, ask your clients for permission first. But if there's a draft order that's being done up, that draft order involves you, and those are obligations upon you, which the courts are somewhat imposing. So it's good if you're going to be the realtor to be involved in what do those terms look like, are they realistic, and is that something that we as lawyers, we make assumptions about how you do your job. But if we draft something that you can't actually adhere to or oblige with, then that's sort of useless.
We talked about that 60-day MLS rule or something like that.
Exactly. So just ask for a copy of the draft order before it goes down or before if they're doing a consent order. Ask to take a look at it and give your feedback. And that's going to really expedite the process rather than going through the process and then realizing, well, we're hung up and we need to go get another court order. And the three things that I do put in all my sale orders is I do try and put in that the realtor's staging, listing, and showing recommendations shall be followed throughout the whole period of time, which it would include access to the house.
Nice.
So, but those are three things that if you get an order and it doesn't say that in it, then perhaps say, can we follow in my staging, my listing, and my showing recommendations?
Does the court order have in there that they're going to sign a realtor? Is that correct? And how does the realtor increase their odds of being part of that process?
If the parties don't agree on a realtor, sometimes we will go to court over which realtor should be assigned. If you find that you're in that situation, there's three things that you can do. The first is maybe find out who the other realtor is, and I don't know, we talked about this before, I don't know how favorable it is to do a co-listing agreement. As you said, somebody has to be a master. That's all news to me.
That's what we prefer. I mean, like it's difficult to follow two masters.
If you don't want to work together, then try and set yourself apart. And the way I have seen realtors do that in the past is they will offer an incentive on the price reduction. So if I'm going to sell this house within 30 days, I'll give you $2,000 off. I had a realtor do that last week to get on a file. And then the other is maybe consider a shorter listing agreement, which sort of tells the court that you're going to bust your butt for 60 days and you're going to get this done. And if you have you need to beat out the other realtor and get your foot in the door so that you're just not a blanket name up in front of the judge. The judge won't know Mr. Smith from Mrs. Smith up there. But you're going to have to figure out a way to beat the other realtor and get assigned to the file.
Nice. Now, for those of you that are struggling to write and keep up, because every time you say there's 3 points, and it's like, this will be posted up. This segment will be posted up after the fact, so don't worry about that. We'll be able to get all this information, and this is going to become a bit of our Bible segment. We also said at the beginning, it's like, every situation is different. Make sure you talk, and results may vary. And
if you have questions, feel free to email me, and I'll find time as long as I don't get 300 questions.
You'll be okay.
But then I'll try and clarify some stuff for you.
Awesome. Tell us about high conflict situations. How do we handle it?
Really high conflict situations, that's where, as I said, you have people that are at odds. So you want to, going back to the transparency rule, really applying that. And just really, one of the things that you might want to negotiate, if you are the chosen realtor, try and negotiate a longer listing agreement.
Right.
Because in a high conflict situation, especially if you have mom or a party that's in the house that does not want to sell the house, you're going to have problems getting access to the house. And I'm sure some of the realtors that are watching this have had those issues. So it's better to have, rather than a 90-day, get your 180-day. So, and then also use that call to view program. I just discovered that on a really high conflict file in the fall, and it was the most beautiful thing ever. I was able to, and actually the realtor put me on the call to view. Maybe you have a different one.
The showing time is showing time is the one that we're using now.
Okay.
You can actually set up people to receive notifications.
Exactly, and I got, every time there was a rejection, I was able to see what was going on. The realtor's comments, I think the mom in that situation was telling all the purchasers that there was asbestos and mold, and like every time it was not every time there was a showing, there was something new that was wrong with dad or wrong with the house.
And but family services step in.
Yeah,
and take
pretty much. And the beautiful thing though is that I was able to print off that call to view or the showing services and attach it to the affidavit, and very easily prove to the court that we have a very difficult seller. So essentially, as a result of that, having all that evidence on one piece of paper, and so readily from a third party, not from dad or realtor putting it together, I was able to get a court order that is effectively, mom had nothing to do with the sale anymore. She was ruled out completely.
Wow.
The realtor, she was cut out after that because she was being so unreasonable.
Wow.
Right? We actually, after that, even after the house sold, mom tried to interfere and told the purchasers that the house hadn't been sold to them, and we had to go to court to get her physically removed from the house. So that's what you would call very high conflict.
Yeah.
So transparency might not have even worked in that situation.
Now, we're going to talk quickly about litigation. Now, most people don't think of this as not like someone slipped on the sidewalk and now someone's suing somebody. When you're going to get a file for divorce, you sometimes need to sue the person. And is that what you're talking about here with litigation?
No, what I was talking about is sometimes when you are a realtor, remember that you are just like any other professional that we retain on a file. Just as a business valuator or a child psychologist, we're going to need some evidence or information from you, such as the call to view or the showing program.
Showing time,
but yeah, you might have to complete an affidavit. I had to get a realtor to come to court in December to make sure that a sale went through. So you might be really involved in the process, and again, it sort of helps, going back to the transparency, that the courts see that you're a neutral party and you're just not there and dad's a jerk and I'm on mom's side or vice versa. So make sure that you're walking in there neutral from the beginning and you're presenting yourself well, because it is a credibility assessment. And then after that, the evidence will be able to put a lot of weight on that.
What do you mean by litigation? Like what is
litigation,
being litigated
it's
here?
just the applications to list the house, the applications to, I had to get the realtor involved to get an offer accepted.
Oh, okay.
So we had wanted to accept an offer. We had a 48-hour window to do it. I had to get the realtor to do an affidavit, come down and speak to the Queen's Bench Court on the fact that this was a legitimate offer.
Right.
Right.
Cool. Awesome. Let's talk about the buying side now.
Okay.
First steps a buying realtor should take on the file.
Always, this is one of the #1 pet peeves of family law lawyers, and I cannot express this enough. This is something that we even put into our retainer agreements, although clients tend to forget about that. If you have a client that is in the middle of a divorce that is coming to you and they're saying, I want to buy a house, the first thing you should do is get the contact information of their family law lawyer and find out, is this the right time for them to be buying a house or putting an offer down? How far in the process are they? If they go, the worst thing that happens is we walk into our office on a Monday morning and we get an email from our client saying, I bought a house this weekend. And I said, well, no, you didn't, because your name's still on this mortgage and we don't have any money and we aren't near far enough into this agreement or into the resolution of your issues for you to be buying, which effectively means that that deal may fall through and you've essentially worked for nothing.
Interesting.
Yes.
Yeah. Be very careful with that. That's a big one. I mean, lots of people are excited to go out and they'll tell you things, and it's not that the client is fully educated on what they or they were told, but it's like.
Well, and sometimes it is the party that is a little bit less intelligent when it comes to finances and what's actually involved in buying a house. Sometimes there has been an imbalance throughout the relationship in terms of they manage everything and they're just thinking, well, I can buy a house. Well, there's a lot of cards that need to come together before you can actually purchase your house.
Prior to putting an offer in, is there anything else a realtor could do to protect the deal?
I think the best thing you can do is, as I said, if a party comes to you and they want to buy a house, talk to the mortgage broker if you can, and find out what is required from that deal. Do you need a fully signed separation agreement? Do they just need a letter? How much funding do they need from the sale of the prior house? And then talk to the realtor. Those two conversations are going to let you know whether you should do any work or not, or whether you have a client that is just maybe a little bit lower on the financial intelligence and they don't understand where they are in the process.
Wow.
Maybe that was a bit of a harsh word, but
no, it's perfect.
They just don't understand how the deal comes together, right?
It's
and
so
what's
true.
involved.
And I've seen that on both sides. I know that my uncle and my aunt, this is probably personal, but she handles everything. And he's just like, yep, you just tell me where to, how much I'm spending and everything else. And
people do get excited, and a lot of times I want my clients to go shopping because they'll be really married to a matrimonial house, and I said, you know what, go shopping, go look, but when you're looking, don't pull the trigger until I say pull the trigger.
Right.
Because if you do that, then you're going to ramp up your legal fees, and you really and this is so significant, is you are really reducing your leverage on your file, because all of a sudden you have a deadline for when you need to have your spousal support, your parenting, and everything settled, whereas the other party does not have that deadline. So unless we can do an interim agreement, which ramps up your legal fees, because we're essentially doing an interim and then a final, but keep in mind the other side doesn't have to consent to anything. And if they refuse to consent to anything, then you just lost your deposit and you lost your deal.
Wow.
And then things stay status quo until we can get through, as I said, the financial disclosure and the proof that nobody can keep the house.
It sounds like a lot of over-communication is required with the lawyers and everything else.
I think the issue that I experience is that there's a little bit of under-communication. The realtors are not asking us. And
right, but they should be over-communicating as a rule.
Just,
it's like,
well,
get the clarification.
Use it with some common sense, because every time you do talk to us, we're not free.
Right.
Good call. So make sure it's something that you need to talk to us. And when you're talking to us, make sure you're communicating with both lawyers at the same time to keep that transparency, as I said. Or if you're wanting to buy, you have a potential buyer, just that one email is going to save you so much. Is it okay for us to put an offer on this house?
Yeah. That's
going to save you some work and the client a ton of stress.
Farrah, that's fantastic information. I like drinking from a fire hose, which is awesome. That's exactly what we want. So thank you so much for your time and coming on the meeting. And we are going to be right back with Russ Austin and David DeLaron talking about how to stay out of RECA jail and how not to get sued. Talk to you soon.